All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning. Welcome to the Kansas Supreme Court. It's so good to have all of you here today. We are glad to have with us a group of KU law students. So I'd ask their professor to come forward and introduce the group to us.
Good morning, Chief Justices. May it please the court, I'm very happy to be here, Professor Uma Autka from University of Kansas School of Law, with 5 excellent law students that are studying environmental law this semester. So have a particular interest in having the chance to observe oral arguments in this Sierra Club case. Lexi Finley, Chloe Garcia, Isabella Solario, Emma Cleland Layton, and Madison Hain. Thank you for allowing us to be here. Thanks.
Thank you and welcome to all of you. And to all others that are in the audience as well as on our YouTube channel. Mr. Doug Shima, is the clerk of our Kansas Appellate Court, and I would ask him at this time to please call the morning docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Friday, February 3rd, 2023 is appeal number 123023, Sierra Club versus Janet Stanek in her official capacity as the Secretary of the Kansas Department of Health and Environment and the Kansas Department of Health and Environment, an agency of the state of Kansas, and also Husky Hogs LLC, Prairie Dog Pork LLC, Rolling Hills Pork LLC, and Stillwater Swine LLC.
Madam Chief Justice and the other justices, good morning. Tim Laughlin on behalf of the petitioner appellee Sierra Club. I'm joined with co-counsel Bob I. We're ready and prepared to argue, and we would ask the court to reserve 4 minutes for rebuttal.
4 minutes is reserved.
Madam Chief Justice, may it please the court. Clayton Kaiser on behalf of the interveners, Husky Hogs LLC, Prairie Dog Pork LLC, Stillwater Swine LLC, Rolling Hills Pork LLC. We are ready and prepared to argue. We would like to split our time 13 minutes to 2 with the Kansas Department of Health and Environment.
May it please the court. My name is Arthur Chalmers. I'm here for Secretary Stanek and the KDHE, and we are present.
Second case is appeal number 125781 in the matter of Robert R. Laing Jr., original action and attorney discipline.
Good morning, Madam Chief Justice, Justices. My name is Julia Hart. I am a deputy disciplinary attorney. I'm appearing on behalf of the petitioner, the Office of the Disciplinary Administrator, ready and present for argument, and I would reserve 3 minutes for rebuttal, please. Thank you.
Robert R. Laing Jr., pro se.
Your Honor, that concludes our docket for 9 a.m.
Thank you, Mr. Shima. Ask the attorneys in 123023 to please come forward. And as you do that, I will just explain to our audience, especially for those who may not be familiar with the court and how the court works, that the court before argument has read the briefs of the parties, have done our own research. We have looked at portions of the record as necessary to help our understanding of the case. So we are familiar with the arguments, and we are looking forward this morning with an exchange with the attorneys to help us better understand some portions or to focus in on specific issues where we would like to have their continued input beyond their written briefs. You'll notice that we have computers and papers in front of us. At times we may be making notes, but at times we may be looking back at some of those documents that those briefs or other documents we have referred to. Doing so helps us sometimes look at the specific language of a statute, for example, or do something else that helps us really focus in on the arguments. So I say that to assure you that when we do that, we are still engaged in the case. We are still listening to what is happening in the courtroom. So it looks like everyone in terms of counsel are settled. So Mr. Laughlin.
Madam Chief Justice, may it please the court. This is a case about whether Sierra Club has the right to protect the waters of Kansas when an agency fails to enforce a law meant to protect it. Associational standing exists to allow an organization to enforce a law that an agency who has the authority and duty to do so fails to do so. Sierra Club would not be before this court today had KDHE done its job.
I interrupt just to ask a practical question that's been bugging me, which is one set of permits has already expired in this case. Husky Hog permit, the Rolling Hills permit expires in late April, and the Line permit expires in late May. Seems to me the cases would become permits expire. So I'd like you to address that. But really the practical thing is, do you really want us to decide this case? Permits are going to expire.
To answer your last question, yes, we would have this court reach the merits. And here's why the court has jurisdiction and why this case is not moot. For starters, it is KDHE's burden to prove mootness, and that burden comes with an evidentiary standard of clear and convincing evidence. The agency has not shown, based on the clear and convincing evidence, that the actual controversy has ended and that the parties' rights will not be affected by a mootness holding. And here's why. So the interveners are still seeking reinstatement of their permits. Now, even though the permits will expire, as Sierra Club has briefed extensively about the mootness exception, just because the permits expire does not mean that the case should be moot. But going back to the actual standard of mootness, KDHE is required to show that the interveners are not seeking reinstatement of their permits. The interveners have continued to seek reinstatement by responding to pleadings. They have not stated otherwise.
I'm going to interrupt. I'm sorry to interrupt the flow of your answer, but you're touched on the one facet of this case that's bothering me, which is how did the original permits get reinstated in the first place? And I know how, because the Court of Appeals said that. But how did the Court of Appeals have authority to reinstate?
Well, by essence of the regulations, the permits were reinstated. Well, the original permits remained in place, but the permit modification only addressed the specific part of the original permit that was modified. So,
okay, so let's talk about that. When an agency modifies a permit, there's only one permit, right? I know there's 4 separate permits, but in each silo, there's only one permit.
That's Sierra Club's stance, and that's the reason.
So how does the Court of Appeals even reach back in time and undo the modification? That's one question I have.
Sure. So it's not a matter of undoing the modification. The modification happened. There's no question that there was a.
What does it
modification.
mean to quote unquote reinstate the original permit?
I think the Court of Appeals meant that because the interveners were continuing to respond to Sierra Club's challenge, that meant that they still had an interest in reinstating the original permit.
Came up to the Court of Appeals on standing, right?
Yeah, it came.
Let me put it this way, the Court of Appeals ruled that your clients did not have standing.
That is correct, Your Honor.
And so then, but in the interim, the KDHE had issued these modified permits, right?
That is correct.
So by what authority, how does the Court of Appeals then get to say, oh, and by the way, we're going to nullify the modified permits? I realize that's what the other side maybe was asking them for, but I don't see how that was an issue in front of them. Especially after they find that there's no standing.
Well, let me try to address your question first based on the mootness and then moving over to the standing. So even if a challenge is considered moot and KDHE met its burden to show that, this case is moot, a mootness exception applies when there's a reasonable expectation that the same parties will be subject to the same action later on. And as Sierra Club has provided this court with the permit renewals that are occurring after the expiration of these permits, it's clear that the same material issue, which is the amount of animal units located at these specific sites, exceed the animal unit threshold requiring a 500-foot setback distance. So because there's a reasonable expectation that Sierra Club, KDHE, and the interveners will be subject to the same proceeding, that creates the exception to the mootness doctrine. And that is why this court can hear this case and why it is not moot. Now, moving to your question of standing, the Court of Appeals made an abstraction of standing when it required Sierra Club to provide its own expert. It relied on the Sierra Club v. Mosier case, which said when causation is a matter of science outside of the common understanding, that the court typically requires expert evidence. We don't have a problem with that. We think that is a rational rationalization. What we have a problem with is that when science can be gleaned and reasoned from the agency record, it is unnecessary and otherwise redundant to require a party relying on that agency record to provide its own additional expert evidence. And that is what Sierra Club has done here. We rely on the water samples contained in the agency record. KDHE and the interveners have not provided any expert evidence to rebut what is in the agency record. That would be a reason to have if a party wants to rebut the agency record, that is a point at which a party should be required to provide their own agency record. But because—
Let me ask you, I'm sorry to interrupt your answer or argument, but you're touching on an issue that stood out to me, which is under the standing test when we're evaluating causation itself, right? And then the panel's argument about the necessity of expert witness testimony. But even going back to this court's decision in Gannon, we've sort of adopted the federal definition of causation under the standing umbrella. And my understanding of the federal decisions interpreting that issue, that standing or the causation requirement is not as rigorous as proximate cause. It's a fairly traceable standard. Is that your understanding? And is that the correct meaning of causation under our controlling precedent?
That is Sierra Club's understanding, Your Honor, and it's based on the preponderance of the evidence, right? This isn't a tort case. We're not trying to prove negligence and damages. This is a preponderance of the evidence case. So as long as there is a logical connection that the asserted facts are making an inference that is trying to be exhibited, that is the standing standard. And KDHE and the interveners would have this court believe that a higher standard applies, and that is just not the case. It is preponderance of the evidence. So
Okay.
yes,
Preponderance of the evidence under a standard that is not the tort standard for causation, right?
correct.
Yes. And then I assume that the record evidence from the agency that you're referring to are the notice letters, the monitoring well information that's showing downstream contaminant levels of nitrates and et cetera.
Yes, Your Honor, and that's correct. And the Court of Appeals really ignored the standard applied in water pollution cases, which is one, a petitioner needs to show that the defendant discharges an effluent, and two, that that effluent either caused or contributed to the injury suffered downstream. And when we look to the agency record, which is presumed to be objective and accurate, unless there is evidence rebutting the accuracy and objectivity, which there's not here, we see that the agency record identified elevated levels of nutrients at the Husky Hog Prairie Dog Pork operation, and that KDHE on its own admission stated that those nutrients cause blue-green algae, and the injury suffered by Mr. Wolf downstream is blue-green algae. And because it is uncontested that there is a hydraulic connection from Prairie Dog Pork to Harlan County Reservoir, we have met the standard under the Cal Palace case and even under the Gaston Copper case, which the Court of Appeals relied on to show that Mr. Wolf has been injured based on the nutrients in excess at the Husky Hog Prairie Dog Pork monitoring wells, and Sierra Club can rely on him for standing purposes, for associational standing purposes.
Court of Appeals seemed to be troubled by the fact that you even admitted there were other contributors. But at this stage of the proceedings, I take it your position is that doesn't matter. That fact that the permittees could be a contributor is sufficient.
The standard is that, oh, sorry, Your Honor. The standard is they either cause or contribute. They don't have to be the sole cause. So yes, that would be our stance now. And when we did discuss meander, it was during the commenting period when we didn't know what the agency record had said and had included. So yes, the standard is that they merely need to contribute to the discharge and injury suffered by our member.
There have to be a showing of how far downstream that make it relevant. I mean, you could find contributors way downstream that might not be related back to the hog farming operation. So where is it? What kind of proximity would be required in your position?
Sure. The court in Crown Central, Friends of the Earth in Crown Central, they ultimately denied the petitioner standing because they didn't show causation. They just relied on the fact that water flowed downstream. But the court stated that if the petitioners in that case had provided water samples or expert evidence, then that would have binded the causal link. So the court in that case didn't make a distinction on the petitioners being located 18 miles downstream. It was just a matter of whether they provided water samples. And in this case, Sierra Club has done that. Those water samples show that the maximum contaminant level has been exceeded, and the nutrients that were identified created blue-green algae, which is the injury of Mr. Wolf has suffered.
Discussion about the Ross's membership and how that impacts standing. What is your position about when, about why that would be important, and at what point in time is their membership need to be? Why that point in time as opposed to others?
Sure. So, standing again is a preponderance of the evidence standard. That is the evidentiary burden. So when all of the parties agree that standing is established in this case when the KJRA brief and petition is filed with the district court. And based on the preponderance of the evidence, it's clear that Sierra Club represented the Rosses during the administrative appeals process, and then subsequent when it filed its opening brief, attaching a declaration with a signed declaration stating that they were members of the Sierra Club. That is the point at which the Ross's membership should have been established, and it was based on the preponderance of the evidence.
I know this case has been really overtaken by discussions of both mootness and standing. I'm wondering if there's not a deeper problem really, which is procedural in nature. So I wanted you to assume for purposes of this line of questioning that your clients in fact do have standing. There's not a problem with necessarily either standing or mootness. But it strikes me there's a problem potentially just with the way this procedurally came up under the Kansas Judicial Review Act. Because you initially challenged the agency's action to issue the original permit.
That's correct, Your Honor.
And the defendants are not operating under those permits, or at least they weren't until the Court of Appeals issued its decision. We're operating under modified permits, right?
The modification only changes the original permit remains in place.
There might be overlap. In other words, provisions from the original might have been carried forward in the modified permit. But it was still a modified permit, right?
The issue here is not necessarily the permits. Those are sort of a secondary issue. The primary controversy here is whether or not KDHE violated the statute, not whether.
But the only way they can violate the statute is by issuing a permit that violates the statute. The permits are the issue.
Well, the animal units located at the facilities, the facility in Phillips County and in Norton County contain the same amount of, or contain an animal unit threshold in either the original and the modified permit that it requires these facilities to be set back 500 feet.
I understand your contention is that even the modified permits are unlawful, but procedurally, there's never been an appeal of the modified permit. In other words, under the Kansas Judicial Review Act, you never petitioned for review of the modified permit.
Well,
and why shouldn't you have to do that?
So we actually did, Your Honor, and that is the second case that is before the district court right now.
Okay, so there is a case pending.
There is a case pending, and the reason Sierra Club did
What are we doing here then?
We wanted to preserve the right for phrase. If this court hadn't accepted this case, we wanted to ensure that we didn't lose our right to challenge the permits, because the modification, while it doesn't get rid of the original permit, it is an extension of that permit. So we needed to appeal that, and we weren't sure if this court would accept this case, but in the event that it didn't, we wanted to make sure that we preserve that right to challenge the permit. So I think that answers your question, but they have been appealed. It's currently stayed before the district.
That makes sense. The court of
Just a clarification, so they're stayed at district court pending this, or they're actively being pursued at district court? The modified permit appeal.
They're stayed pending a decision by this court.
Thank you. Thank you.
And the Court of Appeals in its decision in this case clearly stated that the modified permits were not before them, were not part of what the Court of Appeals was deciding.
That is correct, but Sierra Club would argue that because the original permits are part of that modification, that they were before the court. But the point isn't really that the permits establish the animal units. They establish the violation to the law. But the real issue here is the legal fiction that KDHE created and the interveners suggested that the KDHE approve was that a violation of the setback distance issue? And we would defer to our briefing as to why that was a violation.
But just to be sure I understand, your position would be that if we would say these permits were unlawful, the modifications just fall as well without us issuing an order, because they rest on the validity of the original. You can't modify something that isn't there. Is that what you're saying?
No, Your Honor. We're saying that whether it's the original permits or the modified permits, they both suffer the same flaw. They're both cut from the same common thread, and that is a manipulation of the setback distance established by KSA 65-180. So
what's the manipulation?
The manipulation is this. So it's uncontested that prairie dog pork is within the original bounds of Husky Hog's original permit boundary. It's also uncontested that once prairie dog pork was inserted within that boundary, the animal unit levels rose from 3,702.4 animal units to 6,154. Had Husky Hogs asked KDHE to permit its original permit 500 feet within 500 feet of Prairie Dog Creek with 6,154 animal units and with a separate swine waste management system to accommodate those animal units, KDHE would have denied those permits. And that is because the statute requires setback distances based on animal units at a facility. So that whether it's the original or the modified, we have a animal unit threshold that well exceeds the 3,725 animal unit threshold requiring a 500-foot setback distance. And these facilities are located within 500. So they violate the statute, whether you're looking at the original or modified permits. And we would ask that this court reverse or actually uphold the district court's ruling in that respect.
So does this turn on 65-1180A, which says a facility? Does it kind of turn on what's a facility? Because ownership of a facility was divided here, right? Now there's two separate facilities. If we're persuaded that it was manipulation, but is it still legal under the statute because now it's two facilities?
The issue here, Your Honor, and I think to answer your question, I think perhaps it does center in part around what is a facility, and Sierra Club has presented the argument that a facility is a tract of land, and with these specific facts where we have this previously permitted facility, right? And you subdivide that facility in half. To my previous point, had Husky Hogs in its original permit application asked KDHE to approve that facility, the boundaries within that facility for 6,154 animal units, would have denied that permit. So it makes no sense, especially given the purpose of the statute, which is to prevent an impermissible risk of surface water pollution, to cram in an additional 2,400 plus hogs.
Isn't your argument really just with the statutory fix that the defendants went out and got? I mean, there was an original permit issued, you sued, you won, and the defendants say, oh, bummer, we lost. What are we going to do? Well, we're going to go change the law. And they did that.
Well,
and so, and if that change in the law is bad policy or whatever, isn't your argument with the change in the law?
the statute hasn't changed, Your Honor. The regulations has changed, and the regulation has nothing to do with setbacks. It's a permitting fee regulation. And actually in intervener's final pleading, they admitted that the regulation doesn't apply. It's a permitting fee regulation. So while there have been changes in the regulation, the question isn't whether or not KDHE violated its regulation. The question is whether or not KDHE has violated the statute, and the statute hasn't changed since this challenge has begun.
Give you a hypothetical. If two, and I'm going to get the names mixed up, so I'm just going to say A and B. If A and B were owned by different people at the outset, would you have a case?
Yes, we would, Your Honor, but only if they shared the same legal description and were on the same tract of land. That's the issue here. These facilities are on the same tract of land with the same legal description. And in addition, they all rely on one of the permits to provide the hog, feed, vet, and labor. These are all interconnected. And so but the real point here is they're on the same tract of land. And when you look at the definition of a facility, a confined feeding facility, as defined by KSA 171.
What does that mean they're on the same tract of land?
So tract of land is defined as a specific boundary or something used for like a
I
given,
mean,
given purpose.
Do you mean that two separate legal entities are physically occupying the same ground, or that they share a common boundary?
They share the same legal description. They're on the same.
Let's just say there's a square mile, and you're saying there's two owners of the square mile?
They occupy, so that when we say tract of land in this respect, and specifically the husky hog, prairie dog, pork example, you have a tract of land that is originally permitted as one boundary. That is split.
And then they divide it.
They split it in half.
As a matter of whatever the Register of Deeds might say, or as a matter of law, there are now two tracts of land.
I think what it comes down to is what is the legal description in the permit application, in the KDHE's permit application.
A land, does that change, like when I buy a house, it tells me what section of the tract of land I'm on. So if you convey property to somebody else, doesn't that change the legal description of the tract?
Well, in that example, yes, it would. But here we had a previously permitted facility. And the issue that in order for KDHE to approve that facility, it had to be located within a permissible distance of surface water, where when you're just deeding your home, there's not that restriction, right? I mean, here we have a statute that requires a certain setback distance to surface water. And because we have this original boundary that was set and approved by KDHE, KDHE cannot then allow a certain amount, an additional amount of swine onto that facility without requiring the setback distance, because had the original permit presented that amount of animal units, they would have had to deny the permit because it's located within 500 feet.
Isn't that why they modified the permit?
Well, to my prior point, Your Honor, the modification did nothing to remedy the statute. It added.
Didn't it well, correct me if I'm wrong. Didn't it accommodate the splitting of the tract of one tract into two tracts? In other words, didn't it say previously we were permitting this one big tract, and now we're permitting these two separate tracts, which happen to be next to each other or whatever?
The text of the statute, and I would say no, Your Honor, because the text of the statute states that the agency cannot approve a permit if the swine waste management system at the facility is located not less than a certain distance based on animal units. So the distance itself is set based on the amount of animal units there, and the animal units here exceed the distance, or
That's only if you add the two together. And that's only if you take the total.
That's correct.
I may be completely missing something, but it seems to me it's quite possible that what happened was a division. You're saying you have too many animals, and so they just say, well, we're just going to divide this, and now we don't have to. We have two separate facilities. So now we qualify. Is that oversimplifying too much?
That is just that defeats the intent.
I understand your argument that it defeats the intent,
Sure.
but is that description factually correct about? I know it's way oversimplifying, but
Yeah, I would agree with the oversimplification.
Yeah, and let me clarify something. It also requires when you that they do not have a common swine waste management system. Was that also divided when the herd?
So the prairie dog pork permit has its own swine waste management system. The husky hog permit has its own swine waste.
So that they do have separate waste management systems.
They do, but the statute assumes that there's going to be adequate and separate swine waste management systems, because there are statutes that ensure that the setback distance established in KSA 65-1180 is an additional requirement despite there being a separate swine waste management system.
Where do we turn to for our definition of facility? Isn't it through that amended regulation, or do you have a different approach to that?
Well, facility is defined by the Swine CAFO Act, and it's not very helpful though. It says a swine facility is a facility for swine, so that's not very instructive. So what we do is we look at KSO 65-171D, which incorporates 65-1180 by reference, and it defines a confined feeding facility as a lot for the feeding of swine for food. And when this court gives the ordinary meaning to the word lot, a lot is a tract of land with specific boundaries or used for a specific purpose. And when you look at the purpose and functionality of these permits, it becomes clear that they're on the same tract of land. They rely on Husky Hog to provide all the food, feed, and bedding and labor. They're owned by the same family. You know, they are interconnected. So when we bring it all back to what is a facility, that is what a facility is. A facility is as we say in our brief, a facility is a lot is a facility. You can't have two facilities on a lot. KDHE can permit two facilities on the same lot and get their permitting fee if they want to, but for purposes of setting the setback distance, they must combine the animal units.
I'm concerned about that. You know, we're looking at the facts of this particular case, but in a situation where before the original permit, Husky Hogs. So Husky Hogs decides, the family, and we're going to move to Wisconsin. So we're going to sell our land, but we could, for purposes, for the same use but in order to maximize our profit, we're going to split the land and sell to two different owners. Right. And so the difference would be that the food, the vetting, the labor, would be two separate entities, two separate people. So are they prohibited? I mean, do they have to have a 500-foot setback? Both of those individuals that purchased the land?
Sierra Club would say yes to that, Your Honor. And it's because they're on the same tract of land with the same legal description. You haven't moved them, the facilities at all. I mean, the legal description, and I believe it's attachment C to our to our response to KDHE's supplemental brief. You'll see the description of the land is the exact same for the Husky Hog and Prairie Dog Pork operation, and the same for the Rolling Hills Pork and Stillwater Swine applications. So that's what matters. The statute cares about the concentration of animal units in a given facility, and a facility is defined as a lot or a tract of land.
It's defined as a lot, not a tract of land. And couldn't you, when you purchase the two purchasers, couldn't they go and get the tract redefined? I want my tract. I mean, you're subject to your neighbors, how your neighbor is using the land.
So
Because the county has it surveyed as one tract.
the issue here specifically, Your Honor, is that the original boundary that was set in Husky Hog's original permit, had they asked for this amount of animal units to be located on that one facility within that boundary, it would have been denied. That is the starting point here. And
I have
because
your statutory anchor for that argument, the words existing swine facility and.
No, Your Honor, the anchor for us is that KDHE is required to, the anchor for us is the text of the statute, meaning where it says a specific distance is established by the animal units.
Right, but for the facility, when we go back to Justice Andrzejewski and your question about isn't the key here the facility? Instead of that grant of title creating two facilities. So we would be starting from there. Are we saying no, you can, as long as it still remains as the existing infrastructure of a swine facility, it is the expansion of a swine facility titled in two
So if I understand your question,
Having trouble figuring out, again, back to her example of why I can't devise my property, sell my property to somebody or to, however I would do it, whatever legal mechanism. And in doing that, divide a facility. Because we are talking under the language of the statute, facility is for our starting point, isn't it? That's what I understood your answer to her question to be.
yeah, that's a correct interpretation of the answer. And Sierra Club, when we look at what a confined feeding facility is, it is, to Justice's point, it is a lot. And a lot is defined as a tract of land with a given boundary or for a specific purpose, a given purpose.
You're saying that boundary is set in stone. The time that the very first swine facility.
Our position, Your Honor, would be that if there is already a permitted facility that has been permitted by KDHE, it is arbitrary and it is arbitrary for KDHE to approve a permit that would allow an animal unit capacity that it wouldn't have allowed in the first instance if the animal unit capacity within that original boundary increases. That's the first point, but really,
Then part B of my question is, what if they'd turned that around? And before there was any swine facility, Husky Hogs or the corporation doesn't have a facility, but owns 80 acres of land. They sell off 40 acres to someone else. And then after that, everything happens the same. The original facility is yet the ownership is always different for the two tracts. Does that make a difference?
we think it makes a difference.
Can they do what they've done if they had simply divided the land before they started building facilities?
We think it makes a difference, Your Honor, and you're sort of explaining the Rolling Hills Pork Stillwater swine. But obviously they're owned by the same family, but if they weren't, they're still located on the same tract of land with the same legal description. So that's really the what Sierra Club is saying. If they have the same legal description, that is what rules the day. And when you look at the permit applications, the legal description for the Husky Hog and Prairie Dog Pork operation and for the Rolling Hills Pork and Stillwater Swine is the exact same. And that is the issue here.
They could have done what they are doing. They divided the land first.
If the permit applications had different legal descriptions, then
Didn't they have different legal descriptions? In other words, the outer boundary didn't change, but a non-feedlot strip of ground was added in the middle.
the legal description as provided in the, I believe it's paragraph 6 of KDHE's form permit application is the exact same.
Right.
Based on.
Am I correct in describing that as the outer boundary of the lot?
Yes, Your Honor, the legal description would create the boundary.
But part of the change to the legal description was that it was actually a negative. They subtracted out a strip of land, my description, in the middle of the overall boundary. Is that correct? Just as a factual matter, is that correct?
That's correct, but
So that is a change in the legal description. It may not be relevant, but would you agree that that's at least a change in the legal?
that would be an immaterial change of the legal description because.
Isn't that what the dispute's about? The KDHE and the operators say it is a relevant change, and your position is it's not relevant. Isn't that kind of what this all boils down to?
That's correct, Your Honor. It's not a relevant change because the animal units remain over the threshold established by the statute, and that is the issue.
And their claim, and they can speak for themselves, but again, oversimplifying perhaps is, look, once we changed the legal description and we created that buffer, the buffer, which is not permitted, right? That's no longer part of the feedlot. Now we have halved our animal unit number. No, we no longer have 1,000, we have 2 sets of 500.
That would be intervener's argument.
That's their argument, right?
Correct, correct.
And you're just saying that's a distinction without a difference.
Yeah, you can do whatever you want once inside of that boundary, but as long as once the boundary is set, if the animal units within that boundary exceed the threshold, then you must be required to be set back. It doesn't matter what
if
you
it's a
do.
really big lot and the strip in the middle is actually hundreds of acres and somebody builds a neighborhood in there? I don't know why they would want to between two feedlots, but does it matter?
Well, if it's a really big lot, that would suggest that the legal descriptions would be different. The swine facility would not have the same legal.
So your
descriptions.
argument depends on the fact that even though there was a legal modification, in reality, saying it doesn't make a difference in reality.
That's correct, Your Honor.
One more question. In talking about legal description and lot, you did mention paragraph 6 of the KDHE form, but is the word legal description and lot anywhere in the statutory or regulatory language?
Well, lot is defined, its ordinary meaning is defined as a tract of land. So I mean,
Can you give me the site for that, maybe even when you?
yeah, it's the KSA 171D defines a confined feeding facility as a lot used for the feeding of animals for food. And the tract of land language is the ordinary meaning of the word lot. So the tract of land is, yeah.
Thank you, Mr. Law.
Thank you.
Thank you, Madam Chief Justice. May it please the court, Clayton Kaiser on behalf of the interveners. What I took from the panel's opening questions here is really sort of the fundamental problem for Sierra Club in this case. And it's because KSA 65-1180 says absolutely nothing about ownership, says absolutely nothing about adjacency. It says absolutely nothing with regard to how many facilities can be on a lot, whatever a lot may mean. KSA 65-1180 focuses on two things. Focuses on the number of animal units in a facility, and it focuses on the distance between the waste management system and surface water. It's important to take a step back and look at exactly what does 65-1180 do. 65-1180 deals with swine facilities and water. There are 5 things in that statute which it talks about situations in which a permit cannot be issued. We're focusing on only one of those, and that's 1180 subparts A3. And there, when you look to that statute, again, there's absolutely nothing about, as sort of has become the issue here with respect to how many facilities are on a lot. It's our position, Justice Standridge, that the issue of what is a lot, what is a confined swine facility under 171 is a red herring here. We're not coming to the court here today to say that any one of our 4 facilities is not a swine facility. We agree that it is. The question is looking at this statute, because again, this is all that we're left with at this point, because as your honor's questions have alluded to and indicated, this regulation, which again, we think was wrongly relied upon by the district court, we view it as sort of being basically the epitome of the tail wagging the dog. That regulation dealt with application fees, not with whether or not a permit should be issued. Rather, when you look at that, deciding whether or not a permit should be issued, you look at 65-1180. And again, there's only 2 considerations.
Let me ask you a question about 1180. In A, it says the department shall not approve a permit for construction for construction of a new swine facility or expansion of an existing swine facility. Why is this not, even though, changing ownership and adding the extra waste management system, Why is this not expansion of an existing swine?
And great question, Justice Stangelow. In respect to that, the one thing that gets lost through all of the Three Sierra Club's argument is it's not a mere formality. Each one of these facilities submitted hundreds of pages in their application, and most importantly under 65-1180 is that Husky Hogs, as well as all of the facilities, as Sierra Club conceded, have separate waste management facilities, and that's really what matters under 1180. Justice Standridge, is you're looking at a facility and you're looking at this waste management system. Initially, Prairie Dog Pork, or our initial facility, did not have a second waste management system. However, it now does, and that fundamentally changes the analysis. It's no longer, you can't say, well, if you added 3,000 additional animal units to that initial facility, this would not have been permissible.
When was that added? The other waste management system to make it 2 instead of 1?
It would have been sometime, Justice Rosen, sometime after the summer of 2017, when the fire that precipitated all of this occurred. That is when we began working with KDHE, began working on what this process would look like and unfold, and then taking the necessary steps. I don't know exactly when it happened, but that would have been day 0, would have been sometime in summer of 2017.
That was pre permit in
Yes, Your Honor.
pre-permit. Okay,
Yes,
thank you.
because that's part of the process. This is not something where we just come up with this corporate formality or this artifice to where we create an LLC and now we have a new facility. No, each one of these went through a separate permitting process, which again, most importantly, under 65-1180, dealt with building another waste management facility that is consistent with the requirements in 65-1180. That's what
The only,
Had they not split the land, it wouldn't have mattered if there were two waste management systems, right?
That's an interesting question. And I think that's what the new regulation that KDHE put forth addresses in part. When we look at it, to be clear on this issue is basically an issue now because as Justice Files as well as Justice Stegall alluded to, this case is fundamentally different now as we sit here today than it was in 2018 when this KJRA action was filed. And so when we're looking at this with respect to how many facilities and how many waste management systems are in place, the facts are different today than they were before before the fire in 2017 happened. And so you can't separate out, when you look at the statute, it talks about a facility and a waste management system. So you can't decouple that. It's not a minor change to say, well, we're going to add 2 waste management systems to 1 facility. Rather,
If that were true, because you said facility is irrelevant here. But if it was 1 facility, Husky Hogs had just added another waste management system, then KDHE wouldn't have approved it, right? And in fact,
presumably, yes. But again,
so it does matter what a facility is. Right?
what I'm pushing back on, Your Honor, is this idea that somehow the definition of lot is determinative in this case. It's not. We agree that there are facilities here. And as a result, you have to go through the application process. KDHE has to review that and determine whether or not that facility meets the requirements of both the statute as well as its existing
But really,
regulations.
facility isn't defined in the statute. I mean, and that's why I asked that question before. And, basically what's happened here is, Husky Hogs couldn't get it approved when it was 1 facility. So it's kind of like taking advantage of a tax loophole. Well, we'll go around it and do it this way, and we'll make 2 facilities when really we don't have that much guidance in the regulations or in the statute about what a facility is.
Respectfully, Justice Standards, the way the interveners review that is basically a facility stands, on its own, and the facility is defined by the application. And so, your questions, I believe, when talking about, does the legal description on an application decide whether or not a swine facility is separate from another one? And should we have some sort of special rules that apply for swine facilities versus every other type of real property issue that can arise in the state? And the answer is no. You consistently apply that Justice Stiegel, you'd asked a number of questions with respect to legal descriptions. There are separate deeds, and those deeds were submitted with the applications. This is not an artifice. This is, again, we don't believe that this is some sort of loophole, because that presumes that there's something that we're trying to get around. It's not. Again, if you're going to have a facility, you have to have a separate waste management facility or waste management system. And that's exactly what we have here. And that's what drives the analysis. And that's what matters under the statute. What we have here, and this goes back to, I think, your very early question, Justice Stiegel, with respect to the district or the Court of Appeals reinstatement of the original permits. There are a lot of procedural hiccups in this case from intervener's position, one of which is that remand order. In our estimation, the best approach would have been to remand it back to the district court to dismiss the case and to vacate its order. Because as you allude to, and as the honors know after reading through all of our briefing, there have been many races run at the same time here. So basically, after the district court, which again curiously said we reverse, didn't actually say that the permit should be vacated. It touched off an administrative hearing process, which then begged the question of, well, what do we actually have in the permits? Are these permits revoked or not? And so we received, the interveners received a notice of revocation from KDHE, basically an intent to revoke, which then touched off an administrative process, which has been stayed, and then ultimately resulted in us, based following the district court's order that there must be no butting up or adjacency between the facilities, which again was based on the regulation, not the statute, because as the district court correctly determined, there is no separateness requirement in the statute. The statute is silent on that. Again, it focuses on two things: animal units and separation between the waste management system and surface water for purposes of A3. That's all it does.
Well, it also includes the word facility
It does, Your Honor.
out of it.
I'll attempt to be clear on that, ma'am. With respect to the facility, again, I don't mean to read it out of the statute. I think it does have a purpose. Its purpose is you're looking at the number of animal units in a facility. What I was saying, the red herring issue is we don't disagree what's a facility for determining how many animal units we have in a particular area. We agree that each one of these four separate organizations, facilities must stand on their own. So when you're looking at animal units, you have to attribute to them the number of animal units that are in the permit.
What makes a facility separate? What makes a facility independent, in your opinion? And then
Yes, Your Honor. My opinion would be a separate facility is based on actually receiving a permit for that facility. So again, baked into that process is actually having to go through the legal work of having land, which we did. We attached the deed to there. And then also the waste management system, and also all the other requirements that are in the hundreds of pages of application that were submitted for each one of those facilities. And so if we don't meet those requirements, then we don't have a facility, right? Because we don't have a permit, and therefore it's not operational. And so
is it correct that in your view, there were always separate facilities, even at the very beginning of this, right? In other words, it wasn't a situation of splitting one facility into two facilities. Your claim from the beginning was we have two facilities with two separate waste management.
Since the permits,
is that right?
Well, initially we had one facility, and then the fire occurred.
No, I mean, right, but at the outset of this case,
Yes, Your Honor.
you claimed we have two facilities.
Yes, Your
That's
Honor.
what you said to KDHE and why you got the original permits.
Yes.
The only problem was that the two facilities shared a common border
It is.
as a matter of legal description, correct?
It is.
There were still two separate waste management systems.
Yes,
So you claimed all along we have two facilities.
that's correct.
And then the fix to the common border was to say, okay, fine, we will deed a strip of land that's not part of either facility in between the two.
That's
And
correct.
that was the basis of the modified permit, which included that new legal description. Is that, I had all that correct?
Yes.
Okay, thank you.
And the reason that we appealed that is because, again, we believe that the district court got that wrong. We don't believe that 2818A4 actually, again, tail wagging the dog analogy, that's dealing with application fees.
Why isn't that completely moot since that reg is no longer in existence?
We agree that it is, Your Honor. The reason that we appealed, and mootness was an issue to the Court of Appeals that we briefed. And the reason that we briefed it the way that we did was because at that time, we were concerned about some sort of rule of the law or rule of the case applying to us going forward. We were concerned about that because that decision needs to be vacated. Because again, that regulation does not do what the Kansas Court of Appeals did. And presumably, as opposing counsel alluded to, there's additional litigation going on right now with respect to the modified permits. And we were concerned that could be potentially a rule of the case type application that could say that you guys, or that basically we have a ruling on whether or not a separate tract of land between these two facilities has to be maintained.
If we just say, if this court were just to conclude this case by saying all the issues that are properly before us are moot, and they were moot below and the decisions below were vacated essentially, and the parties can go fight about the modified permit starting in the right place, which is the district court. How would you, is that what you're asking for?
It's one of the things we're asking for, Your Honor. That outcome would be dispositive. And the only thing that I would add to Your Honor's suggestion there would be, as we said in our supplemental brief, we believe that this must be remanded to the district court with order to dismiss the case and to vacate that initial order, basically taking away any potential precedential or law of the case type effect in any future litigation between the parties.
How could it have law of the case effect when it's decided under law that doesn't exist anymore?
Again, going back to, we don't believe that obviously the statute 6511.
I'm talking about the regulation.
Yep.
I know you think the district court misapplied the regulation, but once the regulation goes away, how could even a wrong district court decision have any precedential value or law of the case value?
Well, admittedly, I'm not that creative, Your Honor, but the concern would be that there would be some sort of law of the case type argument going forward. And that's why we would want to get rid of that opinion for whatever sort of creative argument that could be made in the future. We think it was wrong, and in light of that was wrong, it should be addressed and corrected.
What happens in April when all these permits expire?
When they all expire, then we'll have to go through the application.
I mean, I'm presuming, I know it's probably not in our record, isn't that process is well underway?
It is, Your Honor. I do
wait till a permit expires to start getting.
That is correct, Your Honor.
And so, if you could tell me, or if you know, is that being pursued on the basis of the modified permit?
This would not be a modification of the initial permits. These are a new application for permits.
New application. Does the new application include the same legal description as the permit under which your clients are currently operating? In other words, it includes the strip of land.
Yes, it does, Your Honor.
Thank you.
Could you, we started off this with a question about mootness, and counsel, Mr. Laughlin, answered that with, this will asking us not to find it moot because these will present the same material issues in whatever proceeding that we'll be hearing. Will it? And if it does or doesn't, I'm concerned about this moving target kind of thing. When will it ever be heard when the ability to modify regulations and permits exist? So could you address that? When would be the proper time to address this, and why not now?
To answer what I view to be the easier question is right now is not the correct time, Justice Rosen, because what we have right now is I view sort of as a confluence of three different things here. We had we're no longer dealing with the initial permits that we had. We're dealing with modified permits that are set to expire, either to have already expired or will expire in the very near future. We're dealing with underlying facts that are no longer the same. Initially, when this case started and what the district court, it based its entire order on was a regulation that is no longer in effect. And then third, the underlying facts have changed to where, again, we don't believe this is necessary. We don't, again, think the statute requires this, but there is a strip of land now between this. And so those are basically the three bases on which the district court decided this order or issued its order. And if we're going to deal with this issue, it should be presented in a way that actually is not moot in the sense that the facts have changed, the law has changed, and we're now talking about different permits than what were initially filed.
And that's not really mootness, it's really a procedural issue, isn't it? Because the current permit, the authority under which your clients are operating the feedlots has never been presented to a district court under the Judicial Review Act.
That is correct. And the only reason it got this far, I believe, Justice Stiegel, is because, again, we were stuck in this strange procedural place in which, and we agree with the Court of Appeals, that we do have an interest, we being the interveners, in a situation to where the agency has already issued you a permit, allowed you to do what you have done. You have spent the millions of dollars necessary to actually stand up and operate a facility. And then at some point later on, the district court says, no, that should, well, we reverse. And we're left in the state to where, well, how do we actually operate? So we agree with the Court of Appeals that the fact that we were able to go through administrative channels and receive modified permits does not resolve that initial dispute. But where we are now with those modified permits expiring, it's in a much different procedural posture. If maybe.
Have you applied for 2 separate permits going forward?
For each one of the facilities?
No, yes, that's what I mean.
Yes, each facility is applying for a permit.
Is each facility applying for 2 permits? One that includes the strip of land and one that doesn't include the strip.
I believe it is the latter, but I'm not for sure. I can brief the court on that following arguments. As we say here today, I don't know if it is for separate. I believe it's each facility has 1 permit for that facility.
Right, I understand. I guess maybe I'm miscommunicating. There are 2 possible permitting options in terms of the legal description. You say both of them are fine, but your preference is to not have to have the strip of land. So I guess what I'm asking, and that's what we're here talking about. When you go forward looking to get new permits when these expire, are you applying, and maybe I'll ask KDHE's counsel this, are you applying for just a permit with the strip of land, or are you actually trying to do belt and suspenders and apply for both?
My understanding is that the tract of land is baked into that, and
Right.
so it is.
So you've essentially given up on the notion of getting a permit without the tract of land.
I believe that is correct, Your Honor.
Questions?
If I could just briefly conclude, Madam Chief Justice. In conclusion, there are 3 bases for this court not to grant the relief that Sierra Club is seeking here. First, as we just ended with, is mootness. Second is standing for the reasons that we briefed. And then third is KSA 65-1180 says absolutely nothing with respect to ownership or the number of facilities that can be on a lot. And we would encourage the court, if it actually does reach the merits, that it applies the plain language of the statute and vacate the district court's order and remand with a order to dismiss this case.
Chalmers?
Court Justice, may it please the court. I asked for just a couple of minutes and appreciate counsel allowing that. Frankly, the only thing that I would hope to address, but I'll certainly answer whatever, is the statute and its application and whether it's properly before the court. You see, the district court ruled on the basis of a regulation that's no longer in force. Court of Appeals never looked at the statute. In fact, the question of the statute that you had so much wasn't raised in the initial briefing before the Court of Appeals. Came up only when the question of mootness was presented. Now, in this KJR appeal, you're being asked to make a decision on a statute that doesn't have anything to do with permits that no one's operating properly before the court. Certainly that's your judgment on whether you want to do it. But
is it possible for KDHE to issue 2 permits that differ the same entity and they're both sort of, can you have 2 permits at the same time?
no, I don't know whether it's possible or not. I know they won't. I mean, what's happened here is that the 2 permits have expired. The process has begun to renew those. They have hearings, notices, and so forth. As of December, I don't think they had a hearing on those as well. Yeah.
Do you know the answer to my earlier question about whether those the renewal applications are renewals of what we've been calling the modified permits?
Yeah, the new permits would be as it relates to the Hungry Hog and other facility would be basically with the configuration with the strip of land between the two.
What motivated KDHE's change in the setback requirements? Was it this litigation that motivated that? Why did that suddenly occur? That impacts what's happening
The
here.
regulation, Your Honor?
Yes.
I would suspect it had to do with this. The KDHE read its regulation differently than Judge Anderson. After Judge Anderson entered its ruling, they went back and looked at the statute and came up with the new regulation that provides their definition now of what they think is a facility for the purposes of each permit. So I think it probably was motivated by this legislation or by this ruling to some degree. The KDHE, of course, did not appeal Judge Anderson's interpretation from a regulation, and
They didn't appeal, they just changed it.
well, they gave notice to the facility owners that your permits are going to be withdrawn, and that led to the change in circumstances where the facility owners changed the legal boundaries between the property. That led to the new modified permits. And that led to where we are.
Did the issuance of the modified permits effectively cause a withdrawal of the initial permits?
That's going to have to be a legal question that I don't think that the KDHE grappled with. What happened is that there was an administrative appeal filed to their notice, and then that was stayed. And at each juncture, either the intervener or the Sierra Club have requested stays.
A lot of things have been stayed
Yeah.
below, which kind of hamstrings us here.
Yeah,
Don't
and-
you agree with that?
Well, my position when I got involved in this case on the stay is that I was concerned that A, I didn't think the court would reach an issue that would be relevant or pertinent to the issues below. And B, that I feared that it would all become moot because I didn't think we'd get to a decision before the permits themselves would expire. And maybe I forecasted that correctly. I don't know, but they have been stayed. There are just a quick couple of notes on this topic, I guess, that may be interest mostly to Judge Standridge, maybe not, but there is a definition in the statute for existing swine facility. And that's found at 65.1.178. The importance of it really it's a grandfathering thing. It's talking about facilities that existed prior to the act and then trigger the setback requirements and so forth. The permits that were issued here, even the first permits, as I understand it, were considered to be new permits for these facilities. There was a fire and they had new constructions, new facilities. KDHE views the statute as looking at a facility as separate applications and a separate swine waste management systems, buildings, structures, lot 10, and other statutory items with pool or pond. And those are all, as you work through the statutory language that does read a little bit like the IRS code that are in the supplemental brief. I think I set out the sites for that, pages 14 and 15. The KDHE then struggled with that sort of definition and included in its current regulation, which they think accurately responds to when you have separate facilities, which you would have in this instance. I agree with the Intervenors Council that probably here, when you talk about the setback from surface water, the key consideration is the wastewater treatment system. I mean, after all, that's where the potential risk is by way of the setback. And when you have multiple wastewater systems in this instance, that was important to the KDHE in coming up with a regulation that defines what the different facilities.
Mr. Chalmers, you may be the wrong person to ask this, but when we're talking about wastewater systems, I'm not that familiar with it, but what difference does it make if there are two wastewater systems?
Well, the way that it works, generally speaking, and claim nothing more than a 100,000-foot view of it, is you have the animals that are confined. The waste works down into and actually kind of works down underneath the floor and into water. That is then pumped into a lagoon system where it is
processed. And then over a period of time, that system, that wastewater that doesn't take is then used as fertilizer out in the field. All how that's processed, how it's pumped, where it's placed by way of the fields is all part of the system of dealing with that waste. Now, the putting it on the fields is not part of the wastewater system itself, but the processing of getting it from the animal underground into the water and into the lagoon system is. And if you have separate processing, obviously, capacities for how you can process it safely. I mean, these systems are not designed to release water. Designed to capture it, tame it, and then be.
Thank you.
The other point, I guess what I was going to say, unless you've got questions, is that from my client's perspective, we don't think this court ought to, when you don't have facts before it that are presently in existence. That is to say, we've got facilities that are configured differently. We've got different regulation. We don't think it's appropriate for the court to actually construe the statute 65-1180. We think really this appeal ought to be dismissed and was properly dismissed by the Court of Appeals. If you do want to get to that statute, then that it's normal, popular, reasonable meaning, and effectively, when you're trying to figure out whether you've got one or more facilities here, the regulation that the KDHE is employing and solid way to come up with that conclusion. Unless you've got any other questions, I'll sit down.
Were either of these operations existing facilities as you've sort of walked us through the statutory definitions? In other words, did they predate the implementation of the scheme?
The Hungry Hog and Prairie Dog Pork facility, that land had a fire, or that property had a fire, and it was in the rebuilding of it. So I think it was considered by the KDHE as each being a new facility at that point, as opposed to an expansion of the pre-existing facility. It is an interesting point that council raises, and I guess I might address quickly if I can be allowed to do so. The applications talk about sections, range, townships. They also have buried within all the paperwork, the exact legal descriptions, the foots and so forth. To suggest that a facility is based on the township range and section number, which is the same as to say that my neighbor's house is my house. They're really not the same legal descriptions or the same tracks, if that is important. But I think that's probably a short-sighted view of looking at what a facility is under these particular statutes and regulations.
Matter if you divide the land first before building the facilities, or build the facilities and then ownership of the land.
I think if you look at the regulation, I think the common ownership can have a play, and it depends on whether it has one or more wastewater treatment facilities or not. So I guess the best way I can answer that is to refer you back to subsection D 1 and 2 of the administrative reg, which is 2818A4.
Questions for Mr. Chalmers?
Thank you, Ron.
Laughlin, you reserve 4 minutes.
Madam Chief Justice, may it please the court. Just a few points I'd like to address, both from comments from interveners and KDHE. The first is their stance that the statute is complied with if there's a separate swine waste management system, and that cannot be read within the statute. And here's why. The statute reads that KDHE cannot approve a permit if the swine waste management system at the facility is not located within a certain distance based on animal units. So the distance, the setback distance, is based on animal units. And after that distance is established, it's the swine waste management system That is the point at which that distance is measured. It is not what establishes the setback distance. It is the animal units at a given facility. So that claim that from both intervener and from KDHE is incorrect and can't be read into the statute.
Is it right that big picture, I mean, focusing really on the purpose of all this, which is environmental, this is about carrying capacity. In other words, because the reason why we care about animal units is because we're talking about carrying capacity of the land so as not to pollute. So if there are more animal units, the setback distance is greater. Is that right?
That's correct, Your Honor. The more swine, the greater the distance.
Right. And so why wouldn't having multiple wastewater treatment plants reduce the, or I guess I should say, increase the carrying capacity of the land and therefore reduce the setback requirements? Why doesn't that make sense just from an environmental perspective?
Sure. Well, to my prior point, the statute assumes that there's going to be an adequate swine waste management system. The setback distance is an additional requirement. However, the record is clear that runoff from these facilities is not prevented. It's not prevented despite having an adequate swine waste management system. And arguably that's the very purpose of the statute is to.
That would be true whether there's one facility or two facilities, presumably.
Well, presumably, Your Honor, but the point here is that there are animal units in excess of the threshold requiring a 500-foot setback distance. And the text of the statute bases that distance on animal units and not the presence of a swine waste management system.
So you think even if there's one separate wastewater management system for every 10 pigs, still violate the spirit of the rule? And in other words, it would just trying to figure out what's the environmental objection here, not the legal objection.
Well, if you take the argument that swine waste management system is all that matters, right? You could arguably have 6,154 animal units and 100 swine waste management systems, and those could be located wherever, right? They could be located within 250 feet, as long as there was a swine waste management system. That does not meet the objective of the statute.
What is the objective?
I mean, we would defer to the district court's ruling, and it said that, you know, the purpose of KSA 65-1180 is to prevent an impermissible risk of pollution to surface water from swine CAFOs. And opposing counsel said that the court did not reach the statute, but it did. It said that, and it also said that the animal units are what rule the day, and that's exactly what we would have this court adopt. We would have it adopt that rationale and that understanding of the statute. To intervener's second point, they stated that, you know, this was not a loophole. We're not trying to get around anything, but that is directly contrary to intervener counsel Tracer's comment during the district court hearing, which said the purpose of this splitting of the Husky Hog lot was to avoid the setback distance. He said that. And he also said that despite what the court held, they'd find a way around it. So that is just an incorrect characterization of the purpose here. And lastly, intervener's counsel stated that this case is just changed. It's fundamentally different, but that is not true. Intervener conceded that despite the amendment to the regulation doesn't matter. It's a permitting fee regulation. And that's correct. The statute, the issue here is the statute, and the statute has not changed. The statute requires setback distances based on animal units, and we would ask this court to reverse the Court of Appeals standing determination and find that KDHE violated the statute.
There's nowhere in the statute that defines a minimum size of the tract of land per facility.
Not within the statute itself, but when you glean what a confined facility is defined as in the KSA 65-171D, which incorporates by reference, you can make that logical connection that there is a set boundary based on a tract of land or a lot, however you want to look at it. And that has been the argument that Sierra Club has brought this whole time. These facilities are located on the same tract of land with the same legal description, and because of that, KDHE needs to combine the animal units at that given location.
One last question from me. I just want to make sure I understand, and you just said it, 65-171D, C2, this is what you're saying, I think, is that a confined feeding facility defined as a building, a lot, a pen, a pool, or a pond that is used for, and that you're focusing on the word lot, and that is in the regulation, and then you're saying that the common definition of lot is a tract of land.
That is defined by either a boundary or is used for a given purpose. Yes, Your Honor. Thank you.
Thank you to all counsel for your arguments today. The court will take this appeal under advisement. What that means is that later today, the court will begin its conferencing of this case, and that will continue on and off until a decision is issued. When we issue a decision, it is always in writing, and there will be usually a press release that accompanies our issuing of that or filing of that decision, so that the public is aware that the case has been resolved. And that will be posted through usual means of our own website, as well as through legal search engines, a variety of those that exist. So they are available to the public for reading. Although we still have one case left on the 9 o'clock docket, I think it appropriate for us to take a recess now. Ms. Hart and Mr. Laing, I hope you'll bear with us as we do that. And so we will be in recess for 15 minutes to resume the 9 o'clock docket, as well as call the 10:30 docket as we open that session. So thank you.